The Driver's License Conundrum and the Question of Property Rights by Yusuf El. The central issue with driver's licenses is that, under the current legal framework, you are treated as a commercial entity. Your property is registered to a sole proprietorship, which functions as a federal franchise via the 14th Amendment. This places both you and your property within the realm of interstate commerce. Through the widespread ignorance of we the people, the concept of state citizenship and the protection of private property rights has largely been abandoned. The federal government was never delegated the authority to compel such arrangements, but it has assumed this power and the public has acquiesced, which by definition is de facto. To date, no one has properly presented this as an injury to the Supreme Court of the United States under Article 3, Section 2, which grants the Supreme Court of the United States original jurisdiction, as opposed to appellate jurisdiction in cases where a state is a party. As citizens of individual states, under the protection of their respective state constitutions, people should be suing their own state for the injury of depriving them of the right to hold private property rather than requiring that property to be registered under a public federal franchise. If you file suit in state court under common law and then appeal to the Supreme Court of the United States, the court would only review the lower court's handling of the matter rather than making a decisive ruling of the actual injury presented. For this reason, such a matter should be taken to the Supreme Court of the United States under original jurisdiction as an equity case, not a common law dispute over statutes. Equity trusts in the Constitution. Beneficiaries' rights under a trust are enforceable solely in equity, as equity governs the enforcement of contracts. Constitutions, though rarely discussed in these terms, contain all the elements of a trust indenture and function as contractual documents. They delegate specific powers to trustees, government officials, and reserve certain rights to we the people, the beneficiaries. However, 14th Amendment citizens, defined as sole proprietorships in federal franchises and commerce, are not we the people in the constitutional sense. They are creations of the legislature and technically act as trustees of both the federal and state constitutional trust. In equity, one trustee cannot sue another trustee as a beneficiary without potentially violating the trust merger doctrine. The real question. The key issue is whether your property, automobile, home, etc., is private property or registered property of a federal franchise in commerce. If you have a mortgage or an auto loan, your property is not truly yours. It is held in trust with the bank as trustee and you as a beneficiary with only use rights. Banks themselves operate as federal franchises. Until courts at every level recognize the distinction between a private state citizen under a state constitution and a federal sole proprietorship, the courts will continue to claim there is no actionable injury. Constitutional obligations of the states. State constitutions, under their Article I Declaration of Rights, guarantee citizens the right to acquire, possess, and protect property. They should not compel property to be registered to a business entity subject to federal authority, as this effectively renders all property public. This principle is at the heart of cases such as Gonzalez versus Roche, Volume 545, U.S. Reporter, page 1, year 2005, where the Supreme Court ruled that even the cultivation of personal or medicinal cannabis permitted under state law constituted a federal commercial crime under 27 Code of Federal Regulations 72.11. The court's reasoning was that, under the 14th Amendment framework, such activity was inherently commercial, even when no commerce had occurred. The driver's license is a commercial franchise agreement. The modern driver's license is far more than a simple permit to operate a vehicle. It is, in legal effect, a commercial contract between the individual and the state. While the public is told it is merely an identification and safety measure, its structural design and statutory definitions indicate a much deeper jurisdictional and commercial significance. Number 1, presumption of commercial activity. Under statutory and regulatory law, driving is often defined as operating a motor vehicle for hire or compensation. By applying for and accepting a driver's license, the licensee is presumed to have voluntarily entered into the regulated realm of commerce, even if they intend only private non-commercial travel. This presumption shifts the relationship from that of a free individual exercising a right to that of a regulated participant in state controlled commercial activity. Number two, 14th Amendment franchise status. Once property, such as an automobile, is registered to a name associated with a state issued driver's license, that property is effectively linked to a sole proprietorship operating as a federal franchise under the 14th Amendment. This classification places the individual in the position of a trustee within a public commercial trust arrangement, rather than a private state citizen under their state constitution. As a result, property once held privately is treated as public property subject to regulation, fees, and forfeiture. Number three, jurisdictional submission through contract. Mercier's invisible contracts analysis explains that licensing functions as an adhesion contract, a private agreement wherein the licensee accepts state rules, limitations, and enforcement authority as a condition of the license benefit. In court, such agreements override general constitutional protections because private agreements take precedence over broad constitutional clauses. When an individual is cited under traffic codes, the court is enforcing the terms of the license contract, not adjudicating a constitutional right dispute. Number four, voluntary in theory, compelled in practice. While licensing is technically voluntary, refusal to participate triggers statutory penalties so burdensome, including fines, arrests, and impoundment, that most people comply without examining the contractual implications. This mirrors the federal government's broader use of consensual agreements, such as bank account terms or tax forms, to secure jurisdiction without openly declaring compulsion. Number five, remedy and strategic approach. Because driver's licenses are treated as binding commercial agreements, remedies must be approached in equity and contract law rather than solely under common law or constitutional theories. This means challenging, number one, the presumption of commercial use, number two, the voluntary nature of consent, and number three, the adequacy of disclosure regarding the contract's terms and consequences. Until the courts recognize the distinction between a private state citizen's right to travel and the federal franchise relationship created by licensing, the injury to private property rights will continue unabated. The correct jurisdictional and contractual framing is essential to bringing a meaningful challenge.